Hello, I'm William Boyd, Director of Pro Bono Services for the Southern Nevada Senior Law Program. Welcome to our presentation on the healthcare power of attorney. I'm aware that many of you have already volunteered countless hours assisting our seniors at our various pro bono opportunities. I once again thank you for your service, and for those who have not yet had the chance to volunteer, I thank you in advance. The Senior Law Program provides free legal services to those Southern Nevada residents 60 years of age or older. Approximately 50% of all referrals to the Senior Law Program involve fundamental estate planning issues, healthcare power of attorneys, financial power of attorneys, and what I call end-of-life documents. Of course, the ultimate goal is always to avoid probate and guardianship whenever possible. With the assistance of pro bono attorneys handling these types of matters, it frees up our staff attorneys to deal with the other legal issues, such as landlord-tenant, consumer matters, ID theft and scam issues, entitlement program issues such as Medicare, Medicaid, Social Security, and VA. We also receive referrals from Adult Protective Services regarding active financial exploitation and other forms of elder abuse. In those cases, our staff attorneys will meet with the client to determine if they have sufficient capacity to form an attorney-client relationship. If so, we can intervene, revoke any documents the abuser is using to exploit the client, and hopefully stop any further financial exploitation without court intervention. And we know by the time that occurs, the damage has been done and good luck obtaining restitution from the exploiter. Our pro bono opportunities include presentations at our weekly basic estate planning and healthcare power of attorney workshop held at our offices, our healthcare power of attorney mobile workshops held throughout the year at various senior centers and other low-income senior housing facilities throughout Southern Nevada, general education presentations to groups of seniors, and specific presentations on avoiding ID theft and scams, and elder abuse recognition and reporting presentations. Lastly, and of course, individual case placements. The healthcare power of attorney is one of the most important legal documents affecting our seniors' healthcare rights. Seniors in Southern Nevada are given the opportunity, with the services from pro bono attorneys, to execute the healthcare power of attorney during our weekly workshops at our offices and our mobile workshops held throughout Southern Nevada. I've been practicing law since 1986, and because of my practice area and my years in the family court bench, I've always had an appreciation for the importance of having a valid healthcare power of attorney in place. But honestly, I did not fully appreciate its significance, nor the challenges that one can experience without it. That was until I needed it in my own life last year. Let's say you have an aging parent or grandparent who's now suffering from dementia. How are you going to have them placed in an appropriate level of care? Who's going to consent to their ongoing medical care? And let's say they have a revocable trust. How is the successor trustee supposed to take over responsibility for the trust? Without this document, one will be forced into a guardianship court and probate court. To confirm, have you attempted to file a guardianship petition without a doctor's certificate? How do you get a certificate from a treating physician without a healthcare power of attorney? Good luck. Does HIPAA come to mind? Well, I'd like to share with you a few recent scenarios we have encountered at the Senior Law Program. First example, we have an 82-year-old female who lives alone. Her dementia progressed rapidly. Her daughter knew she needed memory care, but without a healthcare power of attorney, the facility refused to speak to her, citing HIPAA, of course. Her doctors couldn't release her medical records or discuss treatment. Her daughter couldn't authorize the necessary medication changes. To get authority, she had to petition for guardianship, a process that took several months. By then, her condition deteriorated severely, not to mention the thousands of dollars in legal fees, which helped drain her savings. Second example, We have a 78-year-old male who suffered a massive stroke. He had always told his son, "Don't let me live on those machines." But without the healthcare power of attorney naming his son as his agent, the hospital defaulted to full code status. His son had to watch as his father had been resuscitated 3 times, against his wishes, of course, while he pursued an emergency guardianship. The court process took about 45 days. He never regained consciousness. Lastly, we have a 75-year-old female with a revocable trust. When she developed advanced Parkinson's, her successor trustee, her niece, couldn't access funds to pay for her home health care. Why? The bank demanded proof of authority, only granted via court order, they said, naming her as the successor trustee. Without that healthcare power of attorney to confirm incapacity or a financial POA, the niece spent months in probate court while her aunt's care lapsed. Just recently, I had a married 85-year-old male who previously named his adult son from a previous marriage as his healthcare agent. He specifically did not want his current spouse of 40 years to have the authority to make healthcare decisions for him. Unfortunately, the healthcare power of attorney was completed at a legal form establishment where the agent was told to sign as a witness. His outpatient healthcare providers did not catch this, and they relied upon the same for healthcare decisions. It was only when he needed to be placed in memory care that the error was identified, and the healthcare provider refused to honor the healthcare power of attorney and instead looked to the spouse as his default surrogate healthcare decision maker. The spouse assumed control over the healthcare, denied visitation to all family members on his side of the family and all his close friends. Without human interaction, and this occurs more often than not in memory care, he succumbed to his dementia 3 months later. We've made substantial modifications to our current healthcare power of attorney, which will go online September 1st of this year, 2025. This training will guide you through the process step by step. If you've already claimed a CLE credit for our former presentation, you'll be able to claim a general CLE credit for this presentation. After reviewing the presentation, please send a confirming email to myself or Veronica Larson here at Southern Nevada Senior Law Program, and we'll make sure that the same is forwarded to the State Bar for credit. I will join you again after the presentation to discuss what to expect should you be so kind as to volunteer your services to help us help our seniors. Enjoy the presentation, and thank you.
Hello, and welcome to the Durable Power of Attorney for Healthcare Decisions training video presented by the Southern Nevada Senior Law Program. If you're watching this video, then you have elected to participate in the Senior Law Program's Pro Bono program. Through your participation in our Pro Bono program, you are helping our office accomplish an important mission, which is empowering seniors through no-cost legal services. Whether that's your participation in an estate planning workshop or one of our mobile power of attorney workshops, you are helping a client execute an important legal document, the healthcare power of attorney. So on behalf of myself and the entire legal team here at the Senior Law Program, I want to thank you for volunteering with our Pro Bono program. All right, let's get to the video. A healthcare power of attorney is a vitally important document and is one of the most important documents that a senior can execute with regards to planning for incapacity. Whether true or not, many of our clients believe that guardianship court is this amorphous court where a judge will appoint a random person to take care of the client, and that person's going to dump them in a care facility, never to be seen from by their loved ones. Now, while this perception is incorrect, it is a perception that our clients have. So it's important to have a conversation with our clients regarding the importance of a healthcare power of attorney, because ultimately a healthcare power of attorney gives the client the power of choice instead of having someone be appointed by guardianship court. It allows the client to specify their wishes and desires regarding their healthcare, and majority of the time creating powers of attorney helps avoid the client's family from having to go to guardianship court and expend money. A healthcare power of attorney can provide peace of mind for both the client and the client's loved ones. in that the client can get that peace of mind and satisfaction that who they want to make decisions for them is going to be abided by, and what they do, and more importantly, what they do not want regarding their health care will be conveyed by their agents to all medical personnel. In our office, guardianship court is usually referred to as the court of last resort, in that that is where people go when individuals have failed to create powers of attorney. Without a healthcare power of attorney, many families may not know a client's wishes and desires for their medical care. I tell clients that a healthcare power of attorney is a conversation document, in that before, during, and after, the client should have continuous conversations with their agents regarding what they do and do not want with regards to their medical care. Now, as attorneys, you know that what we tell clients isn't always what they end up doing. And for many people without a healthcare power of attorney, they will not have a conversation with their family members regarding their wishes and desires for their medical care. That failure to have a conversation and failure to have a healthcare power of attorney can result in legal battles, fights, and emotional distress. Now, in the event of an unexpected medical emergency, having a healthcare power of attorney allows the agents to act quickly and decisively regarding the appropriate care for a client. A healthcare power of attorney is that roadmap that specifies the client's wishes and desires. Now, at the senior law program, our healthcare power of attorney covers a wide range of medical decisions, not just end of life. It encompasses treatments, surgeries, pain medication, as well as end of life care. But what is a healthcare power of attorney, and what does it do? A healthcare power of attorney allows a client to pick a person up to 2 backup people to make healthcare decisions for the client when the client is unable to make decisions for themselves, such as if the client has Alzheimer's, dementia, or is in a coma. Our healthcare power of attorney also gives the agents the authority to place the client in a care facility or skilled nursing facility if the client is unable to medically live at home. All right, now let's go through the senior law program's healthcare power of attorney sections, because that's why you're watching this video. You're watching this video so that you can learn our healthcare power of attorney and help instruct the client through the document to execution. The first page of our healthcare power of attorney is what I like to refer to as the warning section. It gives a lot of statements on what the healthcare power of attorney can and cannot do with regards to the client's wishes and desires. It tells the client that the healthcare power of attorney is a legal document. It states that the client is executing this power of attorney voluntarily. No one's trying to trick the client or force them to sign something that they do not want to sign. It states that the power of attorney for healthcare exists indefinitely unless otherwise specified in the document, or ultimately if the client dies. It is important to emphasize to the client that as long as the client is able to manage their own healthcare decisions, understand options, make clear-headed decisions, and communicate with medical personnel, the healthcare power of attorney will never come into effect. The healthcare document only comes into effect when the client is unable to make decisions for themselves. Tell the client that the client's agents have a duty to act consistently with their wishes and desires. That's why it's important for the client to give as much direction, as much of the roadmap as they can with regards to what they want and what they don't want regarding their healthcare decisions. That first page warning section also states the power of attorney is always revocable as long as the client has capacity and ultimately if the client's alive, and that the most recent executed power of attorney is valid. Last one in time is the most current, is the most valid. Section 1 allows the client to name the first person that they want to make medical decisions for them when they can't, or essentially the first agent. Now, whether it's the first agent, the second agent, or the third agent, we stress to the clients that whoever they name as their agents, those agents do not have to be a relative and they don't have to be local. It can be a trusted friend. You are going to have clients that'll come up to you and say, well, I really want to appoint my daughter, Chelsea, but she lives in Colorado Springs. I guess I'm going to have to appoint my son, Jeff. He's not great at making decisions, but he does live locally. When I encounter those clients, I say, stop, hold on. I'm going to ask you one question. And this is the question, if you encounter this situation, that you should ask the client. And that question is, who do you trust to make decisions for you when you cannot make healthcare decisions for yourself. Whoever that is, that's the person that you want to appoint as your first, second, or third agent. They do not have to be local. That's why we add phone numbers to the healthcare power of attorney. We emphasize to the client they should always choose someone who can cope under pressure, doesn't go to pieces. Don't pick someone out of convenience. It doesn't matter that they don't live locally here. It can be anyone. Now, besides for the full legal name of the people that they want to appoint as their agents, I cannot stress enough how critical phone numbers are. I don't care if they have 500 phone numbers or 2 phone numbers. The client must list any applicable phone numbers. They have to list it in the healthcare power of attorney under the section for that agent. That's how the doctors and medical personnel are going to contact the agent to make healthcare decisions for the client. And on the screen in front of you is our section 1, where the client can appoint the first person to make medical decisions for them when they can't. We do allow for the agent's email address in our healthcare power of attorney. So if the client has their first, second, or third agent's email address, then they would just write that on the designated line. In that bottom paragraph, I want to specify a little bit of a caveat. In Nevada, anyone can be a healthcare power of attorney agent as long as they're of legal age. Like I said, they don't have to be local and it doesn't have to be a family member. But there are certain exceptions where a person cannot be chosen as a healthcare agent. And that's in that bottom paragraph. In that the client cannot appoint their treating provider of healthcare, an employee of their treating provider of healthcare, an operator of a healthcare facility, or an employee of an operator of a healthcare facility, unless those people are either the client's spouse, legal guardian, or individual most closely related to them by blood. Other than that, other than those 4 exceptions, the client can choose anyone, family, friend, random hobo off the street. They can appoint them as long as they are not their client's treating provider of healthcare, employee of their treating provider of healthcare, operator of a healthcare facility, or an employee of an operator of a healthcare facility, unless those people are the client's spouse, legal guardian, or individual most closely related to the client by blood. Section 2 states the name of the second and third person that the client can elect to make healthcare decisions for them when they can't. Similar to the first agent, we want the full legal names and any and all applicable phone numbers for the second and third person. I want to draw your attention to that important paragraph at the bottom of the slide in front of you. If the client does not have a second or third agent, that's perfectly fine. Ultimately, they only need to have one to do the power of attorney, and some people only have one person. Tell the client that's perfectly fine. But in the second and third spaces, if they don't have a second or third agent, we want the client to write in those blanks NA to indicate that the client did not choose anyone. I stress to the client, it's not that I don't trust anyone, it's just that I don't trust anyone. So we don't like blanks in our powers of attorney. They don't have a second or third, have the client write NA in those spaces. And on the screen in front of you is our section 2 that appoints that second and third agent. And similar to the first agent selection, we do allow for email addresses for both the second and third agent. Section 3 is our disqualification paragraph. It allows the client to name any individual that the client never wants to make healthcare decisions on their behalf, even if the doctors can't contact the client's named agents. I've worked with seniors for a very long time, and there are certain things that they're very clear about. And they're very clear about who they never want to have anything, whether that's estate planning or whether that's making healthcare decisions for them. So we added section 3 as that disqualification paragraph. If you have a client who says that I have an individual or individuals who I never want to be called to make healthcare decisions on my behalf, even if the doctors cannot contact my named agents, then they will list those named individuals in section 3, the full legal name of those people, and their relationship to the client. And this is section 3 in our healthcare power of attorney, that disqualification provision, where they will state the people that they never want to be contacted to make healthcare decisions for them under any condition. Section 4 is our affirmation statement. In our healthcare power of attorney, the clients have to make an affirmative statement that they're creating a healthcare power of attorney, and that's what Section 4 does. Section 5 lists the things that the client's agent can and cannot do. For a healthcare power of attorney, the agents have a broad scope of authority. Essentially, everything that the client can do with regards to healthcare decisions, their agents will be able to do. There are certain exceptions. The more extreme things, the agent will either have to have their authority specified by the client in the document, or they'll have to get a court order. And on the next slide, we're going to go into more of those extreme things. The agents will either have to have specific authority designated by the client or a court order. But I want to note before we get to that slide, the bottom paragraph of the slide in front of you. Many times the clients are going to ask you, is this healthcare power of attorney a do not resuscitate or DNR order? Simple answer, no. Only a doctor can give the client a DNR or do not resuscitate order. Essentially, it's an order that says, I don't want my heart shocked. It is not the same thing as a healthcare power of attorney. Our healthcare power of attorney is also not the same thing as a POLST, Physician's Order for Life-Sustaining Treatment, or POLST. A DNR and a POLST can only be prescribed by the client's doctor. And while a POLST does deal with many things similar to a DNR or a healthcare power of attorney regarding the client's wishes and desires, no shocking the heart, things like that with healthcare, they are not the same thing. They work in conjunction, unless specified otherwise, with a healthcare power of attorney. But the thing to remember is a client should execute a healthcare power of attorney as well as a DNR and POLST if that is applicable to their situation, but only a DNR and a POLST can be prescribed by a doctor. On the slide in front of you is our Section 4, that affirmative statement by the client that they're creating a durable power of attorney for healthcare. And that last sentence on the slide in front of you states that this power of attorney shall not be affected by my subsequent incapacity. That's the whole point of this. If the client does not have capacity, this power of attorney should come into play, and we have to make an affirmative statement in our powers of attorney. Section 5 is that broad scope that an agent can and cannot do with regard to healthcare decisions. As you can see, it's a big paragraph in our healthcare power of attorney, but I want to point your attention to that bottom exception paragraph. How I instruct the clients is what you're giving your agents is a broad scope, essentially everything that you can do medically, they'll be able to do, except more extreme medical treatments, such as convulsive treatment, psychosurgery, sterilization, abortion, committing to a mental health facility, or arbitration. Those more extreme things, the client will have to specifically give their agents authority to handle those things, or the agent will have to go to court to get a court order to do those things. Section 6. Section 6 allows the client to add any additional restrictions or desires regarding their health care. It allows them to list things like no blood transfusions, allergies to medication. If they have any medications, they should list it in Section 6. This is the section where if they want to give them more authority, like those convulsive treatments or psychosurgery treatments, this is where they would list it, but they would also provide any additional restrictions in Section 6. Now, Section 6 also has a dual purpose. It allows the client to list any additional desires. If they want a specific music playing in the room when they're passing away, or if they want to be surrounded by their grandkids when they pass away, then this is where they'll list it in Section 6. It doesn't just deal with additional medical restrictions, but also desires when it comes to medical care. It can also be things as innocuous as I want to be surrounded by my cats when I'm taken off life support. These are things the client should think about, but most people don't add anything extra to Section 6. So if the client does not have anything, don't have the client feel pressure to add any additional restrictions or desires. If the client does not have any additional restrictions or desires, they'll simply write NA on those blank lines. And this is Section 6 in our healthcare power of attorney, where they can list any additional restrictions or any additional desires in those bottom two lines, as you'll see at the bottom of your slide. Section 7 states that once a client executes the healthcare power of attorney, it is effective immediately. In that once it's executed and notarized, if the very next day, for instance, the client loses capacity, these are the people that are going to make healthcare decisions for the client. The very bottom of the slide, you'll see that NA statement. We do not put an end date on our healthcare powers of attorney. And we don't do that for a very important reason. Many of our clients, this is it. This is the document that they're going to have through incapacity and ultimately until death. So we don't have an end date. If the client needs to change anything, whether that's a name or a choice, they simply come back and do a new healthcare power of attorney. Section 8. Section 8 is the heart of the healthcare power of attorney document. It allows the client to make decisions regarding pain management and end-of-life decisions. Now I'm going to go through the specific sections on the slide in front of you, and then we're going to look at what the specific subsections of Section 8 look like. I want to stress one important point before we go into the specific subsections. If the client cannot make a decision regarding the specific subsections of Section 8, that's okay. While we encourage clients to provide a roadmap to make it easier for their agents to make decisions regarding their medical care, some clients simply cannot make those decisions. That is okay. Instruct the client after a conversation, if they cannot make a decision regarding the specific subsections of Section 8, that they can X out the entire subsection, date and initial on the side, and then it will default to their agents to make that decision for them. Okay? So stress to them, we want a roadmap. We want those agents to have clear direction, but if not, there is an alternative where they X out the entire subsection, date and initial, and then it defaults to the agents. Now, when it comes to the specific subsections of Section 8, let's first look at subsection 8A and 8B. Now, Section 8A and Section 8B can never have matching choices because the statements are diametrically opposed. Section 8A says, I want to be kept alive via machines, even if I'm brain dead and there's no hope of recovery. I like to call Section 8A my Walt Disney provision. Keep me alive no matter what. If the client wants that, then for 8A, they will initial yes, and for 8B, they'll initial no. Now for 8B, it says that if I am brain dead and I'm on machines and there's no hope of recovery, I want to be taken off life support. If the client does not want to be kept alive via machines, if they're brain dead and there's no hope of reasonable recovery, then for 8A, they should initial no, and for 8B, they should initial yes, because 8A and 8B can never be the same choice. But let's look at the choices. On the screen in front of you, you'll see Section 8A and Section 8B. Section 8A says I want to be on life support regardless of my condition, chances of recovery, or the cost. That's what the client wants, that Walt Disney provision. Then they're going to initial yes for Section 8A. Section 8B says I do not want to be on life support. There's no hope of long-term recovery or survival, and I have a terminal condition. This is I'm brain dead, no hope of recovery, take me off life support provision. That's what the client wants. They'll initial yes for 8B. Sections 8C and 8D deal with feeding tubes and being provided fluids via an IV. This is in a finite circumstance. We have revised sections 8C and 8D for a finite period of time. So section 8C states that after the client is taken off life support, they're brain dead, no reasonable hope of long-term recovery. Section 8C says in that instance, if the client wants a feeding tube, they will initial yes. Many times when a client is brain dead and taken off life support, it's not like in Hollywood, in the movies or on television. It's not instantaneous. There can be a bit of a lag time between being brain dead and taken off life support and officially being declared dead. In that instance, if the client wants it in that finite period of time, the client wants a feeding tube, then for 8C, they will initial yes. Now for 8D, it's essentially the same thing as 8C, except 8D deals with artificial hydration and fluids via an IV. So once again, in that finite instance, client is brain dead, taken off life support, no hope of recovery as they're slowly passing away. If the client wants artificial hydration, then for 8D, they will initial yes. If they don't, they will initial no. Clients have very strong opinions when it comes to feeding tubes and artificial hydration fluids through an IV. So we've separated out those two choices. 8C and 8D can be the same choice, but they do not have to match. And in the screen in front of you, you'll see section 8C, which deals with that artificial nutrition. After I've been taken off life support, if the client wants artificial nutrition, even though they understand that withholding or withdrawal of artificial nutrition may result in death by starvation, they want artificial nutrition. After they're taken off life support, then they'll initial yes. Now, section 8D says after I've been taken off life support, if I want to continue receiving or receive artificial hydration through a IV, even though I understand that withholding that may result in death by dehydration, the client wants artificial hydration in that brief period of time when they're taken off life support and they're brain dead, then for 8D, they will initial yes. Section 8E is a very important section and statement, and we strongly encourage clients to mark or initial yes. What section 8E does is it basically gives the client's agent the latitude on a situation by situation basis to weigh the pros and cons of any and all care and treatment. Essentially, the agents will say, is this care or treatment worth it? Do we get enough gain? Is this something that the client would want? Is the client going to benefit, or is this going to be very detrimental to the client? What section 8E does is it addresses any and all care and treatment, not just end of life. So let's look at that statement. On the screen in front of you, this is our section 8E. I'm going to read it, then I'm going to kind of explain to you how I explain it to clients. It says if you initial yes, you give your agent the ability to weigh the pros and cons of any and all medical, dental, and hearing care and treatment. That's important. We've revised section E to add that dental and hearing care and treatment section. It also says that by initialing yes, you'll give your agents the ability to make decisions that are in your best interest and consistent with the client's desires, if known, and that the agents can decline any care or treatment on behalf of the client if the agent determines that the cons of such care or treatment outweigh the pros. So that's a lot of legalese. It's sometimes difficult for clients to understand that. How I explain it is this. Whenever a client goes to a doctor and the doctor recommends a new treatment or a new drug, the doctor explains to the client the pros and cons of that treatment. And the client internally weighs the pros and cons of whether or not they're going to do this new drug or this new treatment. It's similar to those late night commercials that many of you have probably seen, where it's this new drug and it has this miracle, keep me alive stuff. And then there's like 10 minutes of the things that are wrong with it, including maybe killing the client. The clients weigh those pros and cons every day when they go to a new doctor or they get a new drug or they're prescribed a new dental procedure or a new hearing aid. What section 8E does is it allows those agents to do that same analysis, do that pros and cons for any and all medical, dental, and hearing care and treatment. And that ultimately is similar to the client. If the con of that care or treatment outweighs all the benefits, they instruct, whether it's the doctor, the dentist, or the hearing professional, not to get that care or treatment to the client. It is a good provision to have the client initial yes. However, we do have clients that say, look, I don't care about any of the in-between. I'm only doing this healthcare power of attorney for end-of-life decisions so that I have someone who will pull the plug, essentially. That's okay too. It doesn't have to be initialed yes, but we do strongly encourage a conversation and an analysis with the client regarding why initialing yes for Section 8E is very beneficial. Another example, if the client is at the stage where they have Alzheimer's and dementia, and they need a dental procedure or they need a hearing aid. If they initial yes for Section 8E, their agents can have them get dental procedures and a hearing aid to take care of their day-to-day living. It's a very good provision to initial yes. However, though, it's up to the client. It's ultimately the client's decision. Sections 8F and 8G address pain management and generally reflect the hospice philosophy of comfort care. Now with Section 8F, it's a broad scope pain management provision in that if the client initials yes, they're authorizing their agents to instruct the doctors, medical personnel, to give the client as much pain medication as is necessary to alleviate the client's suffering, regardless of the side effects, such as addiction or death. So essentially, if the client initials yes for Section 8F, anytime they're in pain, they're going to get pain medication regardless of the side effects. Now, Section 8G is fundamentally the same as Section 8F, except it has a limiting provision. If the client initials yes for Section 8G, they're authorizing their agent to instruct the medical personnel that in an incurable or terminal illness condition situation, the client wants as much pain medication to alleviate their suffering regardless of the side effects, death, or addiction. So in that finite instance where the client has an incurable or terminal illness and condition, if the client initials yes, they want as much pain medication to alleviate their suffering. Now, we do have many clients that say, look, in that finite instance, I get it. I'm terminal, I want pain medication. But we have some clients that are very weary of any and all times they're in pain, that they want pain medication. So we've separated out 8F and 8G in that clients can indicate the same choice anytime they're in pain. And in that finite instant, if they want pain, they can choose yes. But Section 8F and Section 8G do not have to match. And on the screen in front of you is Section 8F and Section 8G. Section 8F, once again, anytime the client's in pain, do they want pain medication, regardless of the side effects? And Section 8G, in that finite instance, if they have that incurable or terminal illness and condition, do they want pain medication, regardless of the side effects? Now, Section 9 is our care facility living arrangements provision. We have reworked this provision since the last healthcare power of attorney training video. In Section 9, it allows the client to give the client's agents the power to place the client in an assisted living, skilled nursing, or other long-term care facility when the client is unable to medically live at home. Now, typically our office recommends for Section 9 that the client initial yes, and it should be stressed we recommend that because it allows the agents to place in care facilities without having to go to guardianship court and get a court order to place the client in a facility. Now, Section 9 in our healthcare power of attorney looks like this in the slide in front of you. The first paragraph just basically states I authorize my agent to arrange for a natural person, employee, or basically any community-based service provider to come into the home to provide care for the client. That's an easy one. Many clients are going to tell you, look, I want to live and die in my home. And while that's admirable, that's not entirely feasible in many circumstances. So I stress to them that second paragraph, which is when it's no longer safe for the client to medically live at home, if they initial yes in Section 9, they're authorizing their agents to place them in a facility or home, only when it's no longer safe for the client to live at home. And we add a little section in that paragraph that says before being placed in a facility or home, their agent should discuss and share information concerning the placement with the client when possible. It's a conversation regarding placement. I want to stress that second paragraph because of the fact that many seniors that I encounter, right off the bat, they're going to say, I want to die at my home. That's nice, but not always possible. So emphasize to them that if you initial yes for Section 9, you're not giving your agents this broad authority to just dump you whenever possible, take you out of your home. It's only when you cannot live at home medically, where it's no longer safe. The rest of the healthcare power of attorney is our legalese statements, and that's sections 10 through 14, which state that The agents have the authority to go to court if their authority is challenged. So if somebody pops out of the woodwork and says, no, the client gave me authority to make healthcare decisions, the healthcare power of attorney allows the agents to go to court, get a court order that says, nope, I'm the person who is legally entitled to make healthcare decisions for the client. The healthcare power of attorney has a section that gets around the HIPAA guidelines by allowing the client's agents to review medical documents. It doesn't do much good for the client and their agent to make decisions if they can't review medical documents. It establishes Nevada as the choice of law for the healthcare power of attorney. It states that if any portion of the document should be deemed invalid, it can be severed from the document. It's that severability provision. And it severs the bad provision, but keeps the rest of the document, so the document still remains in effect. And the sections in our healthcare power of attorney, 10 through 14, state that by executing the healthcare power of attorney, the client is revoking any other previously executed healthcare powers of attorney. We also have a signature page for our clients. The statute allows for a notarized document or 2 qualified witnesses. The senior law program's healthcare power of attorney is a notarized document. We don't give the option of, in lieu of a notary, to have witnesses. It's always going to be a notarized document. The client should never sign the healthcare power of attorney until they're in front of the notary, who will fill out the screen in front of you, the certificate of acknowledgement of notary public. In addition to the healthcare power of attorney, we also give the client the option to do what's called a directive to physician. Now, many clients are going to ask you, is this healthcare power of attorney a quote unquote advanced directive or living will? The answer to that question is kind of, which is an advanced directive and living will is usually 2 documents, a healthcare power of attorney and a directive to physician if applicable. So when would a client execute this directive to physician? It's important to know that the only time a client will execute a directive to physician in conjunction with a healthcare power of attorney is if the client does not want to be on life support if they're brain dead and there's no chance of recovery. Essentially, a directive to physician works with the healthcare power of attorney. We like to call it in our office that the directive to physician is the permission slip to the doctor to take the client off life support. If the client has chosen yes in Section 8A of the healthcare power of attorney, if they want that Walt Disney provision, keep me alive no matter what, that client will never fill out a directive to physician. They will only do the healthcare power of attorney. If the client has chosen yes in Section 8B of the healthcare power of attorney, which is, if I'm brain dead, no reasonable hope of recovery, take me off life support, then the client will fill out the directive to physician. But why? Because the directive physician says one thing. That's all the directive to physician states. And that one thing is, if I'm brain dead and there's no reasonable hope of recovery, I want to be taken off life support. That's it. That's all it says. So if they've initialed yes in Section 8B of the healthcare power of attorney, they will fill out the corresponding directive to physician. In the directive to physician, it's a 1-page document, we also have the same choices regarding feeding tubes and hydration via IVs. The client's choices from 8C and 8D will have to match the choices on the directive to physician. In that, if the client wants a feeding tube or hydration in that finite instance where they're taken off life support, brain dead, no reasonable hope of recovery, then they will initial yes in the feeding tube and hydration provisions on the directive to physician. Now, the directive to physician is a witness document in that the client should not sign until they're in front of 2 witnesses who will also witness the document and sign the document. And on the screen in front of you is our sample language regarding our directive to physician. That first paragraph right off the bat, I do not want to be on life support if there's no hope of long-term recovery or survival and I have a terminal condition. Brain dead, no hope of recovery, don't want to be on machines. That's basically what that paragraph says. Those last 2 sections are the exact same sections in the healthcare power of attorney related to artificial nutrition and hydration. That's why they have to match the healthcare power of attorney choices under 8C and 8D. We also provide the clients with the option of what's called a uniform anatomical gift form. What this document is it mirrors the selections that a client can make under the revised Uniform Anatomical Gift Act, where they can donate organs, tissues, and body parts for a specific purpose. It allows the client to express their desires to donate some or all of their body for scientific, educational, therapeutic, or transplant purposes. As the client is filling out this document, I just want to emphasize that sections A and B can never have the same choice under the Uniform Anatomical Gift document. That is because Section A says that the client does not want to donate their body to science. So Section 8 should be initialed yes when a client does not want to donate their body to science and or transplant. Section B should be initialed yes when a client does want to have their body donated to science and or transplant. Because A and B basically says, I don't want it or I do, they can't have the same choice. Now, Section C of this document allows the client to initial the specific purposes by which they want their body to be donated to science and or transplant. Let's look at the specific document because I think it's going to help clarify some points. On the screen in front of you, it's an excerpt from that Uniform Anatomical Gift document. As you can see in Section A, it says, I do not want my agent to make a gift under the revised Uniform Anatomical Gift Act, nor do I want my agent or family to do so for any reason. So if they don't want their body, tissue, or organs donated, then they're going to initial yes for Section A. And yes, I do know that they're initialing yes, I do not want. Section B says, I do want my agents to make a gift. And if they do want to donate their body, tissue, or organs, then they'll initial yes under Section B. Now you see there's a bit of a line in Section B. If there are any exclusions, specific organs or tissues or body parts that the client does not want to have their agents donate, then they can list it on that line. If they're fine with whatever can be used for whatever purpose, then they'll just put NA on that line and initial yes for Section B. Section C is where the client will designate what they want their organs and tissues or body parts to be used for, whether it can be transplant, therapy, research, or education, or all or none. They initial the appropriate sections of what they want their organs, tissues, or body parts to be used for. When it comes to this document, if the client during the healthcare power of attorney says, I want to be an organ and tissue donor, then you will have them execute this document. If it is never mentioned, or if they tell you, I don't want to be an organ and tissue donor, then the client will never execute this document. It's an optional document that we allow the client to execute if they mention that they want to be an organ and tissue donor. They don't worry about having the client execute this Uniform Anatomical Gift document. After the clients have completed the healthcare power of attorney and any ancillary documents, whether that's the directive to physician or the anatomical gift form, we strongly encourage the client to register the healthcare documents with the Secretary of State lockbox. At our office, the client will fill out this registration agreement, which is on the slide in front of you. We attach a copy of the executed healthcare documents, whether that's the directive to physician, anatomical gift, or just the healthcare power of attorney. We email it to the Secretary of State lockbox, and as of the date of this recording, it takes about 2 to 2.5 months for the client to get back a registration card. We tell the client to put that card in their wallet. So if they're in an accident or they go to the hospital and they're unconscious, hospital doctors always check their wallets. They'll see the card. They'll be able to access through the portal the exact healthcare power of attorney, so they'll know who to call in an emergency for that client. Or if they're out of state, the hospital or doctor can contact the Secretary of State lockbox and they'll fax the healthcare power of attorney that's in the lockbox system to that designated medical personnel. It's a very good idea, and we should emphasize it heavily to the client to register their healthcare documents with the Secretary of State, especially because it's free. Many people are not carrying around their healthcare documents every day. I mean, they can, it's a little weird, but they can, but most people are not. So having that document be registered, because it's a vitally important document, designating their wishes and desires and their people, we heavily emphasize register any and all healthcare documents with the Secretary of State lockbox. A couple reminders that I just want to give to you that you should also impart to any client is there's no sensitive information in this document. We don't take social security numbers. We don't take birth dates. This is a document that should be given out. This is a conversation document. It is a public document in that the client has designated agents. They have a job. So any agent listed in the healthcare power of attorney should be given a copy of the document. Don't have the client lock up this document where it cannot be found or accessed. It should be readily accessible. Copies should be given to any and all agents. It should be given a copy to all the client's healthcare providers or designated hospitals that the client may go to, such as if they go to the VA hospital. And emphasize to the client that if they travel, take a copy of this document with them. And that last note, once again, emphasizing, because I can't emphasize it enough, the healthcare power of attorney and any ancillary healthcare documents should be registered with the Secretary of State's lockbox. Well, there you have it. The training video on our new healthcare power of attorney. I want to thank you for watching this video and ultimately for participating in our pro bono program. If you have questions regarding signing up for pro bono service with our office, those questions should be directed to Diane Fearon or William Foy, and their email addresses are on the screen in front of you. If you have questions regarding the content of this training video, please reach out to myself, Chelsea Croton, with my email there on the screen, or to the director of our pro bono program, William Voy. Other than that, you can watch this video as many times as you want. And once again, I want to thank you for participating in the Senior Law Program's pro bono program. Thank you.
Welcome back. Hope you enjoyed the presentation. Now that you've finished, we can talk about what to expect should you decide to volunteer your services at one of our workshops. During the workshop, you will guide the client through both the healthcare power of attorney and the advance directive. They will also sign and fill out the lockbox registration form. Upon completion, the client will be provided with the original and several copies. We'll take a copy back to our offices and register the same with the Secretary of State. Please try to arrive about 10 minutes ahead of time to sign in, meet our staff, and receive your first client. The appointments are scheduled 1 hour apart for a total of 3 hours, which will give you an additional general CLE credit. You don't need to bring anything with you. We'll have the cheat sheets available and anything else you may need. At our larger mobile workshops, we can always use the additional notary support. If you have a notary who would be so willing to donate their time to assist our seniors, or you're willing to donate their time on their behalf, please let us know. It would be greatly appreciated. Just a reminder, of course, the client must initial the form, no check marks, please. Mistakes will be made. We have plenty of replacement pages, especially the dreaded page 4. Please flag me or a member of our staff and we will quickly help. When finished, please notify staff and the notary will join you at your table for final execution of the documents. Now I'd like to discuss some common questions you may encounter. First, the client may already have a healthcare power of attorney from another state or the military, and they may ask whether they need to do a new one for the state of Nevada. My response is usually that the healthcare power of attorney is, under most circumstances, legally enforceable in courts of law here in Nevada. However, you will likely be in a healthcare facility when this issue comes up, where a healthcare professional will be trying to interpret that form. If they encounter a form that they're not familiar with, it looks strange, their initial reaction may be to say, I can't accept this form. This is not, you need to go to court. So I tell the client, why risk it? Let's create a new healthcare power of attorney in the form they're accustomed to seeing and submit it to our Secretary of State's lockbox. The last thing you want to see happen is being forced into guardianship court weeks later, only to have a judge say the healthcare power of attorney from, let's say, North Carolina is legally enforceable here. You didn't need a guardianship after all. After all, it's free. So let's do another one. The client may also ask about preparing a will, financial power of attorney, or other documents. Or they may have another legal matter they want to talk to you about. Try to keep them on task with the healthcare power of attorney. Please inform them the client they can make an appointment with the senior law program to see one of our staff attorneys to discuss those other matters. If we don't handle that particular issue, we can refer them to other legal resources. So please have them call us. I personally had this happen several times in the past couple of months. Unfortunately, the client may say they have no one they can think of to list as an agent. This happens from time to time. After further discussion with the client, and they still have no one, listing the public guardian will be appropriate. Lastly, sometimes the clients will ask if their agent must be the same person as their executor in their will or their successor trustee in a trust if they have one. Of course, the answer is no. The same person you trust with your financial affairs may not be the same person you trust making those healthcare decisions for you. Now, let me take a moment to talk about client capacity. Our target population for our mobile workshops are seniors who still have the capacity to live independently. This does come up from time to time. Before guiding the client through the forms, try to engage them in an introductory conversation and ask specifically about their choice of agents, such as their relationship to the agent. For example, the client may say, "I'm choosing my adult daughter." The follow-up question may be, "Do you have any other adult children? And why is this one rather than any of the others?" If you have any questions regarding the client's capacity, please call me over. Or if I'm not available, one of our staff attorneys will be there. We will meet with the client together and decide whether to proceed or have the client come to our offices for further evaluation. Lastly, discussing the client's choice of agent or agents with them can lead to red flags. For example, they might have just met the proposed agent at a casino or bar or another public area. Or it's someone they have only known for a relatively short period of time with no prior familiar or addictive relationship. Again, in this situation, please don't hesitate to discuss the issue with me or one of our staff attorneys at the event. And we may have to ask the client to come to our offices for further evaluation and consultation. But we do not encounter these issues that often. They do arise from time to time. We hope you have found this presentation to be helpful. If you have any questions or concerns, please don't hesitate to get in touch with me directly at wvoy@snslp.org. Thank you again for your willingness to help us help our seniors, and have a good day. Thank you.